Water quality standards are a particular part of the Clean Water Act, which is very important, but is rather specialized. In fact, I will unmodestly say that unfortunately, there are very few lawyers in the environmental movement who work on this much. And that is an issue that we have nationally because a lot of these water quality standards are national standards, or they the problem is, as we'll go into in greater detail, is the standards are established in each state, but they are what will kill a fish in Idaho is not a whole lot different from what will kill a fish in Oregon. But both states have to do the same problems, have established their own standards, but it involves a lot of the same science and law. But unfortunately, we don't really have access to the resources. In a more ideal world, people in Idaho would be able to call up somebody who would be able to talk about what will hurt trout in Idaho, which is probably a lot like what will hurt trout in Montana, but we don't really have knowledge like that. And in some states, people are relatively sophisticated, and in other states, they have no idea what's going on. So why don't we go to the next slide, Gloria? I bring that in just because that gives me an excuse to talk a little bit about my background. I'm a lawyer. I live in Chicago. I've been working on environmental issues since 1982 actively, and I've been working with the Clean Water Act before that. In fact, my father worked in the water pollution business too. So that is my background. I've been the legal legal advisor to the Illinois chapter of the Sierra Club since 1982. So let's go to the next slide here. All right. We're going to have a lot of words here, and I'm not going to expect you to read them all, but I hope that Gloria will send this stuff out so that you can read them all later. But what we're first going to talk about is why any of this is important and why anybody should care what water quality standards are like. Presumably, what we're trying to do is keep the water clean, and that's what you're interested in. And this involves water quality standards where the rubber meets the road is in two areas. First has to do with permits. Now, permits, NPDES permits, National Pollution Discharge Elimination System permits, have limits in them. So basically, the idea was we were going to allow people to discharge until 1985, but everybody's permit was going to have the more strict of the technology-based effluent limit and whatever was necessary to meet the water quality standards. You may have heard the phrase, the solution to pollution is not dilution. Well, that is true to some extent. As to the technology-based standards that we've established, that's required of all dischargers fitting into a particular class. So if I operate a steel mill, I can't put more than so many pounds of zinc in the water, depending on how much steel I make. So that's a technology-based standard. Basically, we require all cars to have taillights, whether we think they need them or not. And that doesn't matter what kind of road you drive on. Everybody has to have a taillight. However, water quality standards go back actually the 1948 Act. Technically, the Clean Water Act are the 1972 amendments to the 1948 Federal Water Pollution Control Act. That's very important. I know you all want to share that at parties and things. But water quality standards was actually the original approach. And under the Water Pollution Control Act of 1948, states were supposed to establish standards, and then they were supposed to use means to prevent violations of those standards. Unfortunately, it didn't work very well, and that's why we had the 72 Act. The key thing for this, though, is it's the water pollution standards will drive the limits in your National Pollution Discharge Elimination System permits. Because remember, it's the more strict we're supposed to use, either the technology-based limit or the water quality-based limit. We call them T-bells for technology-based and Q-bells for water quality-based. As I said, the T-bell is based on what we expect some class of discharger to meet across the country, no matter where they discharge. But, if you're driving in the mountains or something, you may need special equipment. Or if you're discharging to a small stream, just doing what's good for everybody won't work. It's not a one-size-fits-all thing as far as water quality goes. So to meet the water quality standards, we're going to require a more strict limit to avoid violating the water quality standards. So it's key, particularly because the T-bells, the sad history of the Clean Water Act is when they passed this in 1972, the expectation was that EPA was going to make stronger and stronger technology-based limits so that they would eliminate discharges. There weren't supposed to be any more discharges after 1985. And the idea was that so we didn't have to, that would be all gone. Of course, that's not what happened. And in fact, EPA has not updated its technology-based standards very well. And so more and more we're more and more relying on water quality-based standards in order to protect our waters. Okay, let's go to the next slide. Next, Gloria. Okay, so this is part of what I said here before. So water quality standards drive NPDES permits. You get what I just said to you about the stronger of the T-bells and the Q-bells. Then here's the other big area, which is TMDLs. We've got all sorts of great letters here. You get to use a lot of nomenclature. I know in the Sierra Club, we're not supposed to use secret codes. However, I'm afraid that EPA uses them, and if you don't learn them, you're not going to be able to demand that they use your language. In one of the worst acronyms in the federal government, Total Maximum Daily Loads, or TMDLs, is a program under Section 303D of the Clean Water Act, which says that every state should list waters that aren't meeting water quality standards, and then develop a total maximum daily load of what kind of pollution those waters can stand. And the water quality standards are used in setting those limits. So let's say, for example, we have a class of waters, we'll say lakes, and the state has decided that lakes can't have more than 5 milligrams per liter of black in them. They just made up that pollution. So, and we find, lo and behold, that we have 7 milligrams per liter of black in that lake. That would mean the lake was impaired, and so it would have to have a TMDL to design a program to get the lake down from 7 to 5 so that it was meeting standards. Now, you won't have a TMDL, you won't force this sort of cleanup plan if the water quality standard is too weak, or if it doesn't have a water quality standard applicable to this pollutant. So, if the water quality standard were 10, then having 7 milligrams per liter of black would be fine. But that might not be good if over 5 killed all the fish or made it impossible to swim there. Okay, let's go to the next. This is another, anti-degradation is considered a standard. This is an area that I've worked on a lot. It's considered a standard. It's really something slightly different. And but this sort of, this isn't a numeric standard. This doesn't work the way everything else does. It's sort of a super standard. What it says is, first of all, we're not going to allow new pollution. And anti-degradation only deals with new pollution. Essentially, if it's going to hurt anything that's there now. And Tier 2 says we're not going to allow unnecessary pollution. So to use my example of black again in the lake, somebody comes in and they want to put more black in the lake. Let's say that the standard is, let's say that the standard again is 5. Currently, there's 2 milligrams per liter of black in the lake. Somebody wants to add it up so that it would be then 6. The answer to that is no can do. That's not legal, because that would be permitting something that would be a violation of water quality standards. But let's say we wanted to go from 2 to 3. Well, at that point, they will allow that new pollution, but they're only supposed to allow it if it is, I'm going to turn this dang phone off. They're only supposed to allow it if it's been proven to be necessary to accommodate important social or economic development. And this comes up a fair amount, and we've managed to get a lot of reductions in some of the states I work in, or at least avoided new loadings by saying, you haven't proven that this is necessary. Now, generally, it's the necessary component of this that runs in it. So they come in and say, oh, we want to build a new widget factory. It's going to employ 100 people. So it's great for the county. And so we want to raise the level of black in the lake from 2 to 4 because they're going to be they're going to have all these new jobs. And what we argue in many cases, or have argued, is, well, it's great that you're opening this new widget factory. However, you haven't proven that it's necessary. In fact, we know that if you connect the flusel hose to the whatchamadiggit well, like they've done at other plants, you won't need to put all that black in the water. So it's not necessary to do that. So state agency, you shouldn't grant them that permit. And that's been an argument we've used a lot. I see all sorts of discussion between Elaine and Debbie on tier 3, which I don't focus on too much, but basically that's the third category. There are certain states are allowed to designate certain waters, or are supposed to create a category and designate certain waters that they're not going to let new pollution in for love or money. The problem with that is, while the federal government requires the tier 2 be created, or these outstanding national resource waters be created as a category, they don't require any states to put those, to designate anything. So a lot of states have provisions for outstanding national resource waters, but they don't have any designated. Illinois is in that category, and a lot of other states are in that category. So I don't harp on tier 3 too much. Let's go to the next slide. I'm pleased to see, however, that some states have designated these categories of tier 3 waters, and that means that they get this super protection from new pollution. Okay. So how do we come up with these water quality standards? And the answer is that they are basically, it's a state issue. This goes back to the 48 Act again. So it's the states that in almost all cases are supposed to come up with the water quality standards. This is in some ways unfortunate because the states don't have laboratories and generally often don't have the will to establish tough water quality standards. Congress did recognize that, and in general, US EPA does the science and recommends to the states criteria. So, for example, on ammonia, EPA adopted new ammonia standards, which are stronger than most of the existing state standards. However, that doesn't mean that the states automatically adopt them. In fact, they often don't. And we'll talk about that some later. But except with a few exceptions, which had to do with the Great Lakes, and then there are priority pollutants, which is a relatively small portion of the pollutants out there. I always joke that the guys working on air and energy, of course, have it easy. There's really only 4 or 5 air pollutants that anybody worries about, but there are 15,000 different pollutants that we have in waters that we have to think about in one situation or another. But it's generally US EPA that does the science, and the states are supposed to adopt that in order to protect their waters. Next slide, please. Okay. The state criteria are supposed to be based on a sound scientific rationale. And normally it's US EPA that's supposed to provide that, or some states do their own, do their own research, or, depending on your state, you might come in with a water quality standard, and you might have your own research to do that too. But most often it's US EPA that is recommended criteria for states to adopt. And then when the states adopt those criteria, they're supposed to do what protects the uses. Okay, maybe I hope I treat this in the next slide. So let's go to the next slide and see what I said. Okay, so this is all kind of abstract. So let's break it down. First of all, I don't know if we have the same philosophies that we had before, but by and large, environmentalists hate the term uses for waters, and that driving the whole system, because we think that protecting nature is a good in itself, and that we shouldn't be just talking about the value of streams in terms of their use. However, that is the term that's used in the Clean Water Act. So we look at what the state is supposed to do, and in most cases has done, is they designate uses of water bodies. So for example, a stream in Wisconsin, which I know a little better than some, they might designate a particular stream as a cold water fishery, a drinking water source, for recreation, for fishing, and also for fish consumption. Now, if you have all of those uses designated for that water, that means the state's supposed to adopt criteria to protect each of those uses. So because I picked out a cold water fishery as opposed to a warm water fishery, we're going to find out that the standards for dissolved oxygen are going to have to be much tighter, and the standards for ammonia are going to have to be much tighter, because trout can't put up with much ammonia, and they need a lot of dissolved oxygen in the water to breathe. If I designated that stream a warm water fishery, then I could get away with more ammonia and less dissolved oxygen. Now, some of the states have very lumpy standards. Ohio has a lot of different use designations. So, they've got a wide menu of things. Illinois, it's pretty much general use. or doesn't, non-fishable, swimmable. So we have a very lumpy category of uses. As a result, we have a lot of trouble with what criteria are you to use when you've got basically the same general use category for the whole state. Iowa was the same way, that they have very lumpy uses. And in fact, a lot of states just have, 2 or 3 different use categories. And as a result, it makes it harder to decide what your criteria should be. Okay, let's go on here. Some things, for example, though, it might meet water quality standards for one thing and be bad for something else. For example, we've got all sorts of waters in the country that are not meeting mercury standards for fish consumption, because if people eat a lot of fish, they'll suffer from the mercury. The fish really don't give a damn. I had in a big argument with an Iowa lawyer, Illinois lawyer for great length, because she couldn't understand why the aquatic life standard should be more strict than the human health standard for Illinois streams as to radium. Well, most human beings don't come into contact with the stream enough so that radium is going to be as important to human beings as it is to aquatic wildlife. So she kept saying, well, why should the standard to protect otters be stronger than it is to be human beings? Well, the otter's in the water all the time, Debbie. It's constantly exposed to radium. So we have to have stricter standards to protect aquatic life in this particular case than to protect human beings in this particular case. Generally, it's the other way around. Okay, let's talk about, let's stop for a second. Does anybody have any questions? I've seen all sorts of things in the chat, but I haven't tried to address any of them. But why don't we stop for a second before I rattle further? Are there questions? Okay, then I will rattle on.
I do have my hand raised. I'm sorry I couldn't get the microphone cleared. So what happened after we decided we didn't have any protected water? I mean, you knew what the problem we had in Iowa. And then the legislature decided to do a use attainability analysis of all of our streams. And the reason I say that is because for some reason our chapter director got a hold of all of the dischargers that didn't have an NPDES permit. They needed to, it was under, they have to review them, reinstate them, whatever you want to call it. And when she found out, is because the receiving waters, I don't know if that's the correct term or not, didn't have a designated use because they hadn't gone under a designated use analysis. So I know Iowa has a lot of unique problems because we're just that kind of special people here. So I just thought I'd bring up that use attainability analysis is really important, and that goes to determine its designated use.
Well, let me use attainability analysis is important, but let me go into that a little bit. Like I said, every state's supposed to designate uses, and a lot of states, like Illinois, designated most of their waters as fishable, swimmable in the early 70s, because at that time there was federal money going to, a lot of federal money going to wastewater treatment plants and other places. And so if you had more problems, you got more money. So it behooved the state to decide to hold their waters to a higher standard. Iowa, however, missed all that money, and they essentially designated almost all of their waters. The nomenclature is different and it varies from state to state. So I don't want to, it's hard to say. What we call general use in Illinois is actually fishable, swimmable, meaning it's meeting Clean Water Act standards. What Iowa calls general use is garbage. That's waters that we're giving up on. So in Iowa, like 60% of the waters were designated general use. But what a use attainability analysis does is it's a practice that the state is supposed to use before it redesignates a water. Usually, it's done in order to downgrade the water. So you've got a water in Illinois, for example, which was designated general use, and they might say, well, this particular waterway, it's totally, it's concrete lined, it is completely channelized, it's never going to support a fishery. So we don't have to protect it for fish. And that's the way you get this sort of use attainability analysis. In Iowa and some other states, well, including Illinois, and they have use attainability analyses were forced on the state to tell them, you've got to upgrade this. So for example, Illinois used to have all sorts of states, or I'm sorry, all sorts of waters that were designated as not fishable, swimmable. But US EPA said, hey, those waterways, they may have been totally trashed in 1972, but they've cleaned up enough now that we think that they could attain a fishable, swimmable category if you looked at them. And so a lot of those waters were upgraded, and that happened to some of the waters in Iowa, but we've had this in other issues in Ohio. They've done a similar thing. Okay. This is
Elaine's got her hand up.
okay.
Yeah, it's an interesting situation. Seattle's river, the Duwamish, is a Superfund site. And there was a water quality that was based on how contaminated the fish were. And then it was based on how much each person ate of a fish. And the portion was so small, they said, well, we're going to have to change all the numbers here. So they increased the amount of fish that people were eating to determine whether that water should be remediated for water quality. And at the same time, they changed the EPA guidelines on what was, toxic for humans. And so they were playing around with a bunch of numbers there, Albert, like increasing the number of fish, but lowering what the EPA toxic standard was. And I don't remember what they finally came up with, but that was that was the criteria to determine whether that body of water met water quality standards.
Right. Well, that's an example. The water body was designated for fish consumption.
Yes.
Question is, then what criteria do you use to determine that? And the states, play with those numbers because it costs them a lot of money to clean up pollution or to avoid pollution. I know Nina Bell has done a huge amount of fighting in Oregon about just those sorts of things. So if you have a group of people who eat a lot, this has been a particular problem in the Northwest where you have a lot of people who are eating a lot of fish, and some of their numbers just don't compute when they were doing that with the figures they were working. And it's a kind of tricky, frankly, it's a very difficult standard to set, because what you're trying to do with the fish consumption standard is decide what water quality, what level of pollution in the water column is acceptable so that the fish living their life in the water pick up only an acceptable amount of mercury or PCBs,
Mm-hmm.
so that a person eating a normal amount of fish, or will not have too much mercury or PCBs or PFAS or whatever there is that you're concerned about. So the fish consumption standards are particularly difficult to work out. Now we've got two different types of standards, numeric, and they look like something like 10 milligrams per liter, which is the nitrate standard in most states, or they have standards that are something like the water shall be free from unnatural plant or algal growth. And the problem with those kinds of standards is that the guys who write permits have no idea what to do with them. So they tend to ignore them. Legally, the guys who write permits should not ignore them. In fact, they're legally required to turn standards like the waters of the state shall be free from unnatural plant or algal growth into a numeric limit that is actually enforceable. We raised this with regard to a permit of a community south of Chicago and said, you got too much phosphorus in the water. There is unnatural plant and algal growth there. You got to put a limit in New Lenox's permit for phosphorus. And the response from IEPA was that that standard, free from unnatural plant and algal growth, is very difficult to implement. That was their answer. We argued to the Pollution Control Board that we were unaware of a very difficult exception to the Clean Water Act, and they had to implement it, whether it was very difficult or not. The board couldn't find a very difficult exception either, and so eventually we got a limit in the permit. It wasn't as good as we should have had, but it was a limit. So that's an issue in a lot of places, particularly with regard to nutrients, which I've spent a lot of time on, and because a lot of states don't have numeric nutrient limits. I could talk a lot about Iowa, but I'm not going to because that's just too painful. I will mention that.
Hey, Albert, we'll get them when hell freezes over.
Yeah, you will. I was quoted in the Des Moines Register as saying that Iowa was to water quality what Mississippi was to civil rights in 1962. So anyway, next slide. Okay. How do we come up with the numeric standards? Now, most of them are aquatic life because a lot of the numeric standards are generated. This is painful. Nobody can see when Bismarck said that, but they often attribute to Bismarck a line that lovers of laws and sausages should not see how they're made. Well, this phrase also applies to water quality standards. Most water quality standards are to protect aquatic life. And the way they do this is they take totally non-consenting critters and they dump them in tanks full of poison, and they count how many of them die. And if 50% of them die within an hour or so, I've forgotten the exact time, that's the LC50. And the LC50 then they drop a wide variety of critters in tanks full of toxins, and then they're supposed to come up with a formula which protects the 95th percentile of critters. It's very complicated numbers. These numbers are wonderful because they're computed to the 8th decimal point, but they're all based on counting dead critters in tanks. And that is that's the aquatic life criteria. The swimming and aesthetics. Well, swimming, you have pathogen levels. And so we're generally trying to knock down the pathogens so that people don't catch diseases from swimming in the water. On aesthetics, most states run it on I know it when I see it basis. So essentially, if the state official goes out to the lake and sees that it's full of green gunk and that nobody in his right mind will jump in there, they'll say that it's violating swimming and aesthetic standards. But they're not encouraged to find a lot of impairments these days, so they tend to be pretty liberal as to what people will find suitable for swimming. They have done things like user surveys in some places like northern Minnesota or Florida. They find that part of this is social. Some people, I'm certain in Iowa, everybody likes to dive into green gunk water, but in northern Minnesota, they want their water to be fairly clean. So you've got different, you got different standards on that. And then we talked about human health effects, which is difficult. Let's go to the next slide. Okay. Your state, in theory, is supposed to go over its standards every 3 years, the so-called triennial review. In practice, states don't do that. I joke that it's a centennial review, but in theory, every 3 years, they're supposed to consider their water quality standards. I think Wisconsin has finally had something that they call a triennial review, but what most states do is they do a triennial review, or they designate something as a triennial review whenever they feel like it. But they don't do it. And that's something you might want to work on as a volunteer in your various states, is ask your state regulatory agency when they've done their last triennial review and what they're going to consider in their next triennial review. Because as I said, if your standards haven't been updated, they won't be protective. And there's been a lot of science done. And so you have different problems. In some states, pretty much the state agency is the only one who can propose changes. You can complain to US EPA if the state hasn't upgraded for a long time. In Illinois and some other states, citizens can petition for changes. So we have petitioned and said, IEPA hasn't upgraded the ammonia standard in 20 years, Pollution Control Board, you should do it. And so that's an option in some states, it's not in others. And every state has its own way of doing it wrong. But by and large, in some states, Wisconsin, it literally takes an act of the state legislature to approve a new water quality standard. In Montana, they approved good water quality standards, and then the legislature disapproved them. But states set water quality standards by and large. US EPA has tried to force states to do it, but they haven't really worked on it very hard. Or at least, well, let's go to the next slide. But basically, so I'll just this is the law. This is what's supposed to happen at least once every 3-year period. They're supposed to reconsider. They don't. Next slide. That's too sad to read. That's what the law says. The law in 35 cents won't get you a phone call. So they're not doing a triennial review. US EPA did pass a new regulation a few years ago saying that if US EPA has recently adopted a new criteria or has adopted a new criteria since your last triennial review, then you should consider this. So for example, a whole lot of states have ammonia standards based on the 1982, I think it is, ammonia criteria that was put out by US EPA. US EPA put out a new ammonia criteria in, I think, 2015 or thereabouts, which is more strict in some ways. But states by and large have ignored that because if they adopt the new US EPA criteria, then their dischargers will have to do better, and that will cost their dischargers money. So US EPA passed a new regulation saying that if we have a new criteria, you're supposed to at least consider it in your next triennial review. Well, that's nice, except that the states don't do their triennial reviews regularly. And furthermore, if they blow off this requirement, what happens? So let's go to the next slide. Okay, so they established new regulations. They went through pretty easily. And next slide. Okay. so as I said, it's completely unclear what US EPA will do if states don't do anything. And in fact, that's what's happening. There's new US EPA criteria for ammonia, and a lot of states have just ignored it. And that's not the only thing. There's new EPA criteria for lake nutrients and a bunch of other things. And to some extent, the states don't do it because they don't have their agencies are underfunded and they don't have the technical expertise, even when EPA has written the criteria to go in and get a state standard. We'll see what happens on PFAS. Now, on the Drinking Water Act, it's different because that goes immediately on the drinking water. But if they adopt they should adopt a PFAS standard for fish consumption, for example. There was a study done recently which found a very high level of PFAS in a lot of fish that people are eating. EPA should develop a PFAS fish consumption standard. That would have to go through the states. Whether the states will do it or not, well, US EPA has not yet developed the criteria, but once they do, and they say they're working on it, then it's going to go through the states, and we'll see what happens there, or if anything happens. There's a whole lot of US EPA criteria that haven't been adopted. There are some criteria, like the Illinois chloride standard, is 500 milligrams per liter. Nobody knows where the hell that came from. It's lost in the sands of time. And as I said, my father worked in this business. At one point, he was looking at a bunch of water quality standards for some state in the mid 60s or late 60s. And he asked, where did these numbers come from as to a certain class of waters? And he was told that those numbers were what was necessary to protect the interior of a steam locomotive engine if you used water from the creek to put in the steam locomotive to make steam.
Oh, jeez.
Well, we don't run as many steam locomotives as we used to, so those numbers weren't really relevant. And that's how often some of these standards are revised, which is sad. So let's look at the next slide. Here's another problem. I've been involved in a few of these cases. The Kentucky Waterways Alliance versus Johnson is one of my cases. Northwest Environmental Advocates versus US EPA, I think, has to do with fish consumption in Oregon. The problem is, under the law, when a state revises standards, in order for it to go into effect, they have to present it to US EPA, which has to approve it or disapprove it. The pressure on US EPA to approve is politically often overwhelming, because despite whatever the Republicans tell you, US EPA handles all of the states with kid gloves. And they have authority. US EPA has clear authority to go in and establish a standard when it's necessary. They've done that about twice in the history of the agency. I mean, it's very rarely done. For EPA to get tough with a state on water quality standards is considered by US EPA as sort of equivalent to sending troops to Little Rock to take over the public school system. I mean, they are just totally loath to do it. So that is what happens. They often approve these standards even when they shouldn't, when they're not supported by sound science. And the only thing we can do is to sue them under the Administrative Procedure Act. And often, or sometimes, we win and the standards are sent back to the states. Unfortunately, the courts generally grant great deference to US EPA because, of course, the federal judge doesn't know what the proper mercury standard is for fish consumption in Wisconsin. And we just got a very bad decision in Minnesota over some standards that may affect wild rice harvesting by Native Americans in Wisconsin. And the judge just bent over backwards to say, yeah, it sure looks like what they did might not work out, but who am I? I'm just a federal judge. And EPA is the agency that's supposed to approve these things, so I'm not going to overturn it. So let's go to slide number 17. And this is what I said. If they in the case of Florida on nutrient standards, they actually adopted nutrient standards. They adopted lousy nutrient standards, so we complained about that. But while the case was pending over the lousy standards that US EPA adopted because Florida wouldn't, Florida said, oh, well, we'll go ahead and now propose standards. So EPA immediately said, oh my God, wonderful, we don't have to drink from this cup. So they let Florida go back. Florida, now having been chastened by having US EPA have to do it, came up with standards which were even weaker than the ones that US EPA proposed. These new standards were now approved by US EPA, and that's what we got. And so finally, then, I think we're to the last slide here. Nope.
No.
Yes, well, that's the last thing we tried. Another, this is my life. I was involved in this case too. We tried to force the administrator to write standards for nutrients in the Mississippi, and that basically the judge said, well, EPA says that they don't want to do this. They're going to let the states come up with their own approach, but we'll let it see if it works. Of course, it didn't work. And at some point, we might go back into court and say, see, we told you it wouldn't work, and lo and behold, it didn't work. But that's where we are on that. Next slide. Questions? That is not in the Mississippi Valley. That is Stralsund on the Baltic Sea. But I thought I'd end somewhere rather than just have a question slide. Okay, we've got 9 minutes. I've taken some questions, so I haven't been a total Nazi here. And we've got 9 minutes for additional questions if there are any. Or however long you want to go. I don't have a opera date tonight.
I think that Elaine's got her hand up.
Yeah, Albert, I'm still confused by the technical water quality thing and the water quality standards, because you gave an example of how in of manufacturing that they couldn't release a certain amount of zinc or whatever it was. But which is there a precedence of, is there like a priority system that one of those standards has more priority over the protection of the water? What, how do they interact?
They're supposed, the state is supposed to write a permit with a limit that's the more strong of the two.
Oh, the stronger of the two. Okay.
So if the technology-based limit says you can't discharge more than 20, but the water quality standard says you can't discharge more than 10, then
Okay.
the 10 is supposed to be the number in the permit.
Okay, thanks.
I mean, the theory behind that, the dischargers, the dischargers have an answer for both things. If you go with the technology-based standard, the dischargers say, oh, that's just pollution control for pollution control's sake. It doesn't protect anything. Well, that's not true. But if you put in the water quality-based limit, they say, oh, well, that's too expensive. That's not the technology-based limit that we worked out because everybody could meet it easily. But that's what we're supposed to do, is the stronger of the two, because we want the idea is to eliminate discharges, and the idea is to protect things that we've got there now. So we want to have and protect uses. So we want the stronger of the two, but the constant effort of the dischargers in states is to adopt the weaker of the two.
Albert, this all sounds so depressing. Is there, with this new EPA administrator, Reagan, do you see any changes?
Well, hey, I'm always a very cheerful person, as all of you who know me would say. I'm very optimistic all the time, and I'm known for my Pollyanna attitude. So I'm surprised that my presentation you found depressing, but I do want to stress that I think the Clean Water Act, by and large, has been a remarkably successful law. I mean, murder has been illegal for a long time. They talk about Cain and Abel, but still people commit murder. So you can't control reality by putting words on paper, although that's what I try and do as a lawyer. That's my career. We have words on paper and we try and create reality with that, or control reality with that. And there's a limit to what you can do with that. And so I tended to point out the various problems. There's a reason why I pointed out the problems, though, because you guys are all powerful people. And by going in and talking to your state agencies and asking questions and commenting on permits and working on standards, you can have an effect that will cause them to enforce rules that they wanted to enforce otherwise, or to do things that they wanted to enforce otherwise. I got off on a long speech and I forgot what your precise question was.
Oh, whether there were any positive improvements in the EPA with the new administration?
Oh, well, the bad news is that, yeah, I mean, it's better. That PFAS standard wouldn't have come out under a Trump administrator. Although sometimes things move under the radar. There was the lake nutrient standards were adopted under Trump. It just wasn't. I mean, the good news about the Trump administration was that the politicos didn't reach down far enough to understand what was going on in many places. So the EPA officials could do some things, and as long as it wasn't too loud or get too many complaints, they could get a lot of things through. I've had some people say that the EPA was never better than it was under the last 2 years of the Reagan administration. And that's because there'd been all sorts of scandals in the Reagan administration with Ann Gorsuch and Rita Lavelle went to prison, and Watts and all those people. And so, the agencies all seem to, they're looking at who's going to win the next election. So right now they're all sort of hugging first base. And if Biden's reelected, they'll take a bigger lead off towards second, if you can get my analogy, for a few years, but then they'll start worrying about 2028 and they'll get more cautious again because the bureaucrats don't want to be the hero who proposed a wonderful new program and then lo and behold, there was a change in administrations. Now the politicos are going to be gone whenever there's a change of administration, so they do the best they can. Sometimes they don't care. Some people like for example, the Region 5 administrator that Trump appointed, she was fairly harmless. She had no idea how the agency ran. She went and cut ribbons and things. She didn't really hurt anything. So she was fine in the sense that she didn't get in the way of anything. If God forbid Trump's elected again, they might appoint somebody who's competently evil, and then we'll have real trouble.
I think one last question. Donna, you've got your hand up.
Yeah. How is our beavers affected with the water? since they live in the water too.
Yeah, the beavers would be, I gave you an example of that, actually, that the water quality standards are supposed to protect aquatic life. And so, for example, and that includes wildlife. I think I talked about the radon standard. We had a big argument over the radon standard because the radon standard, it's been a long time since I looked at this, but it was something like 4 picocuries, which is a different thing. Radon is radioactive, and so it causes cancer by virtue of being radioactive. And so the standard there was actually developed to protect mainly aquatic life, things like beavers and otters that are in the water all the time, because the standards are supposed to protect the most sensitive use. So if your most sensitive use is fish consumption, then the operative standard for mercury is the fish consumption standard. If your most sensitive use is aquatic life like beavers or otters for radon, and I don't know what else is like that, then the standard is supposed to protect the most sensitive use there.
Oh,
Something I find fascinating is that if you're supposed to be fishable and swimmable, so fish need food, so the standard should be able to protect the food of fish, like the flies.
Well, that's generally what in fact, when I was talking about killing critters in tanks, they drop in a fathead minnow, a mayfly. They've got 2 or 3 other critters that they drop in these tanks and count how many of them die. And those are generally things that are at the bottom of the food chain. Though they're also concerned because often the bottom of the food chain is not the thing that's most sensitive to pollutants, because the bottom of the food chain often doesn't live very long. I mean, there's a lot of things out there that don't catch cancer, because I mean the fish don't care about the radon level. They're going to die of something else before the radon's going to kill them from cancer. But the beavers and the otters are in the stream long enough so that they will be killed by cancer if the radon level's too high.
all right, well, it's 8:01. Thank you very much, Albert.
The last thing I'd just like to stress is I'm willing to come out and talk to your state if you've got a particular problem for, just I give advice for nothing. If you want to do a lot of work, then I have to do more.
You also get a learning experience in sarcasm.
Yeah, exactly. I give courses in sarcasm, and but then also if the Sierra Club ever has money again, it would be really nice, or if the environmental movement ever wanted to work on these issues a lot again, it would really be nice to have expertise in these areas so that we could, advise people in Missouri as to, changes in their radon standard. I'm not an expert in radon, but you get all of these water quality proposals and all of these water quality standards that need to be upgraded. And how in the hell is a volunteer conservation chair in Tennessee supposed to know whether the selenium standard is protective in Tennessee or not?
Well, Albert, Water Sentinel's been pushing to get somebody on staff at the Sierra Club National that is a water expert that wouldn't do all of it, but would certainly be a big step forward.
Right.
We don't have anybody at the policy level right now.
Well, we could all talk about the history of the Sierra Club on this and the fact that we used to have paid staff, but I think part of the problem is Madoff, but then there are other issues too. Okay. Shall we say